All right, good evening, everyone. Welcome to Monday, March 30th, Somerville Condo Review Board. Pursuant to Chapter 2 of the Acts of 2025, this meeting of the Condo Review Board will be conducted via remote participation. We will post an audio recording, audio-video recording, transcript, or other comprehensive record of these proceedings as soon as possible after the meeting on the Somerville city website and local cable access government channels. Um, Ben, if we could please conduct a roll call vote to ensure we have a quorum.
Okay. Chair Zasloff,
Present.
Vice Chair Byrne,
Here.
Board Member Simeon,
Present.
Board Member Solis. Board Member Solis does not appear to be present, but with 3 in attendance, we have a quorum.
All right, very good. Thank you very much. And at this time, I will motion to call this evening's meeting to order. And our first item on this evening's agenda will be some administrative cleanup. And again, I will pass it back to Ben as he has an exciting staff announcement to present.
Yes. So our first staff announcement is that we have our new liaison to the Condo Review Board, who began earlier in March, Lauren Chapman, who is joining us this evening. And just before, Lauren, I'd love you to introduce yourself. I just want to say to everyone here as well, this is going to be the last board meeting where I will be leading as staff to the board. I know. And I just want to say once again that this has been a really an excellent experience for me. It's been great to get to know everyone, to work with you all, to step outside of my comfort zone and in my role with the city and do something very different. And I feel like it's been incredibly enriching. So thank you, enriching. Thank you for that. And Lauren, why don't you unmute and give a quick introduction?
Yeah, absolutely. Hello, everybody. I'm the new housing policy coordinator in the housing division and the staff liaison to the CRB. I have lived in Somerville for 6 years now. I'm on Walnut Street, but I'm originally from Dragon, Massachusetts. So Massachusetts is my home, and I'm really excited to be working for the city as a resident and now more formally. I'm really excited to support this board and learn more from all of you about this process. And Ben has done a wonderful job training me, so I feel like I've been in good hands.
All right, fantastic. We're excited to have you join. And again, a big thank you to Ben for jumping in and supporting the board. You know, he was fantastic in that endeavor. So Ben, graciously thank you from the board on everything that you've done to support us over the last few, probably 6 months now, right?
About 6 months. Yeah.
Yeah.
Thank you, Zach. Thank you.
And Vice Chair Byrne, would you like to
Of
give?
course. I can't stop that. So yeah, I just want to say thank you, Ben. It's been really great to work with you. You've been a real treat, and it's been really nice. So thank you for all you. And Lauren, I look forward to getting to know you and you.
All right.
Wonderful.
Thank you for those kind words, Vice Chair Byrne. Board Member Simeon, anything from you to the group?
Well, it was a pleasure, Ben, to be, with you. And you were very supportive, especially when I personally cannot jump on the meeting. You so, patient and to make sure everybody on board. Thank you for that. We will be missing.
Thanks so much.
Mhm.
Thanks, everyone. Likewise, it was just again, it's really, I had a wonderful time working with you all and learning about all of this. So I think it was just as just as an interesting and great of an experience for me as hopefully it was a good experience. Hopefully I was able to support all of you. Thank you.
All right. Very well. Thank you, everyone. All right. Continuing through the administrative items, we have meeting minutes from the last meeting, February 2026. I'm sure all board members have had a chance to review those meeting minutes. So at this time, open the floor if there's any discussion or edits, anything you'd like to call out before we proceed to a vote for approval.
Comment.
All right, seeing no edits or discussion around the February 2026 meeting minutes, motion to close the floor and motion to uh, conduct a vote on approving the February 2026 meeting minutes.
Okay, this is a vote to approve the meeting minutes for February 2026. Chair Zasloff,
Yes.
Vice Chair Byrne,
Yes.
Board Member Simeon.
Yes.
The motion passes.
All right, and the one last item under the administrative portion of tonight's agenda is a vote on the transmission of the annual report fiscal year 25 for City Council's approval. We mistakenly last month when we approved the annual report, we did not vote on the transmission of that report to City Council. So we will do that this evening. Motion to vote on the transmission of the fiscal year 25 annual report to the City Council for approval.
All right, this is a motion to approve to a transmission of the fiscal year 2025 annual report to City Council. Chair Zasloff,
Yes.
Vice Chair Byrne, Vice Chair Byrne. We may have lost Vice Chair Byrne.
Looks like we lost Board Member Simeon also.
I will attempt to reach out to Board Member Simeon and see if he needs any support with rejoining. Oh, there's Board Member Solis. Okay. Um, Board Member Solis, welcome. We are appears to be we're having some technical difficulties. So Board Member Simeon and Vice Chair Burton just appear to have dropped from the call. So we are working on getting them back so that we can continue with the meeting.
Okay, thank you. Lauren, welcome. It's nice to meet you.
Thank you. It's nice to meet you as well.
Just apologies to everyone in attendance. It sounds like there is a power outage in part of Somerville, which we can attribute to two of our board members dropping off the call. So they are both working on getting connected again. It sounds like the power is back on, but that is our delay.
So sorry. I'm here. Okay. Yes.
Yes.
You hear me, please?
Yes.
Yeah. Oh, boy. Sorry. The whole house without electricity. That's what's happened. Yeah. Sorry.
That's all right. I know Vice Chair Byrne is still working on getting back onto the call, but maybe we can continue on for the moment, or Joe.
Yeah, through you, Chair. It may just make sense to take a quick roll call to just establish that quorum, as we've reestablished quorum.
Yep. So, motion to conduct a roll call vote to ensure that we have a quorum.
Yes. Okay. Chair Zasloff.
Present.
Vice Chair Byrne is not currently present. Board Member Simeon. Sorry, I couldn't hear. Could you say that again?
Yes. Present.
Okay, wonderful.
You hear me? Yeah.
Yes, I can now.
Good.
Thank you.
Thank you.
Board Member Solis.
Present.
Okay, with 3 in attendance, we have a quorum.
All right. So, I believe we were voting on we had conducted a motion to vote on the transmission of the fiscal year 25 annual report to the city council for approval.
Yes, I will go ahead and restate. You're making a motion to vote once again?
Correct.
Okay. This is a motion to vote on the approval of a transmission of the fiscal year 2025 annual report to City Council. Chair Zasloff,
Yes.
Board Member Simeon,
Yes.
Board Member Solis,
She just dropped too. It wouldn't be the final meeting unless we threw you a curveball, send you out on the high note.
I think that everyone just wanted to throw something new at me. Just when I thought I had seen it all.
Yeah. One thing I've learned in life, you've never seen it all.
Certainly not.
There's a curveball somewhere for you.
We made it through some dicey winter nights too in the last couple meetings. 70-degree day.
I'm going to reach out and encourage our other board members to join via their mobile devices if they're able, and I can promote them to panelists. Give me just a moment. There is. I'm going to reach out to our vice chair as well. But Board Member Solis, are you having experiencing power outages as well?
So I'm not experiencing power outage. I just had a total, it just like completely shut down on me, the meeting, like it bumped me out. I'm not sure why.
Your connect
I have
doesn't.
had the lights flicker once, but yeah.
Okay. Okay. Thanks everyone for your patience. I think let's take a quick roll call once again and can attempt to continue on.
Okay, motion to conduct a roll call vote to ensure we have a quorum.
Okay, Chair Zasloff,
Yes.
Vice Chair Byrne is not currently present. Board Member Simeon,
Yes.
Board Member Solis.
Yes.
Okay, with 3 in attendance, we have a quorum. Chair Zasloff, do you mind just motioning once again to vote on the transmission of the annual report?
Yes, this is a motion for the board to vote on the transmission of the fiscal year 25 annual report to the city council for their approval.
Okay, this is a motion to vote on the transmission of the fiscal year 2025 annual report to City Council. Chair Zasloff,
Yes.
Board Member Simeon,
Yes.
Board Member Solis.
Yes.
The motion passes.
All right. We are on to the new business section of this evening's agenda. And first, we will be reviewing the applications for final and/or courtesy permits. First application from the board this evening is 6 MacArthur Street, represented by Attorney Sheehan, and that's the application of 6 MacArthur Street LLC. Lana Kokri and Nancy Barros, managers seeking final conversion permit for Unit 1, Unit 2 at 6 MacArthur Street.
Yes, hello. And before I start, I just want to say, Ben, best luck in the future. It was a pleasure working with you. And Lauren, I look forward to working with you in the future.
Thanks, Attorney Sheehan.
Absolutely. Mark Sheen of Adam Dash and Associates, attorney for 6 MacArthur Street LLC of 6 MacArthur Street. My client is seeking final conversion permit for units 1 and 2 of this multifamily residence. The property was delivered vacant to my client and has remained that way since the closing date. My client has submitted the remaining 2 items required by the board, which are a master deed and a property condition report. So now the board has a complete application. Thank you.
Thank you, attorney. On that note, a motion to open the floor for board discussion. If there's any questions for the attorney regarding the completed application. All right, seeing no discussion amongst the board, motion to close the floor and motion to open the public commentary period. If anyone in the virtual audience would like to speak in favor or against the application at 6 MacArthur Street, now would be the time to do so.
Okay, please raise your hand if you would like to speak. I don't see any hands.
All right, seeing there's no public comments, motion to close the public commentary period. And in reviewing the application, we were awaiting 2 final documents to complete the application, that being the master deed and the engineer's report. Both have been submitted, which completes the application process. And at this time, I'm prepared to make a motion for the board to vote on the final conversion permit for Unit 1 and Unit 2, both located at 6 MacArthur Street.
Okay, this is a motion to vote on a final conversion permit for units number 1 and number 2 at 6 MacArthur Street. Chair Zasloff,
Yes.
Board Member Simeon,
Yes.
Board Member Solis.
Yes.
The motion passes.
All right. Thank you very much. Moving along, next application under the final, who's seeking a final conversion permit is 10 Bartlett Street, represented by Attorney Vigorito. This is the application of Turnpike Prop LLC. Leonardo Ribeiro, seeking final conversion permit for Units 1 and Unit 2, both located at 10 Bartlett Street.
Good evening, Attorney Ann Vigorito, 424 Broadway, Somerville, Massachusetts. I'm here this evening. I represent Turnpike Property LLC. Leonardo Ribeiro is the manager. I was before the board back on July 28th of 2025, seeking a preliminary non-rental conversion permit for Units 1 and Unit 2. At that time, you did not have a master deed or an engineer's report. At this time, you do have those items. So I'd be respectfully requesting the non-owner rental conversion permits. Thank you.
All right. Thank you very much. Motion to open the floor for board discussions or questions for the applicant. Seeing there's no discussion amongst the board, motion to close the floor and motion to open the floor for public commentary. If anyone in the virtual audience would like to speak in favor or against this final conversion permit this evening, now would be the time to do so.
I see no hands.
All right, motion to close the public commentary for 10 Bartlett Street. At this time, with both outstanding documents now being submitted, it completes the application process. We've now received the master deed and engineer's report. So I am comfortable making a motion for the board to vote on the final conversion permits for Units 1 and Unit 2, both located at 10 Bartlett Street.
Okay, this is a motion to vote on a final conversion permit for unit number 1 and number 2 at 10 Bartlett Street. Chair Zasloff,
Yes.
Board Member Simeon,
Yes.
Board Member Solis.
Yes.
The motion passes.
Thank you, everyone. See you in a little bit.
All right, thank you. Moving along, we have the application of 21-23 Kent Court LLC seeking final conversion permits for units 1, 2, and 3 located at 21-23 Kent Court. Do we have a representative for this application?
Tigran, hopefully I'm pronouncing that correctly.
Yes.
It should be.
Yes, good evening, everyone. My name is Tigran. Yes, I am. This is Victor Torrejan, my partner, my business partner. We're located at 100 Henno Street, Unit 19 in Alston, Mass. We're seeking for final conversion permit for 21-23 Kent LLC, Unit 1, 2, and 3.
All right, thank you very much. This time I will motion to open the floor for board discussion or questions for the applicant. Seeing no discussion amongst the board, motion to close the floor. Motion to open the floor for public commentary. If anyone in the virtual audience would like to speak in favor or against the application at 21-23 Kent Court, now would be the time to do so.
I don't see any hands.
All right. Motion to close the public commentary. And then reviewing the application, again, 2 outstanding items, both have been submitted to the board. That includes the master deed and engineer's report. At this time, that completes the application process for 21-23 Kent Court. So at this time, I would like to make a motion for the board to vote on the final conversion permits for units 1, 2, and 3, all located at 21-23 Kent Court.
Okay, sorry about that. This is a motion to vote on a, excuse me, this is a motion to vote on a final conversion permit for units number 1, number 2, and number 3 at 21-23 Kent Court. Chair Zasloff,
Yes.
Board Member Simeon,
Yes.
Board Member Solis,
Yes.
the motion passes.
Thank you. Have a good night.
Thank you very much. Have a good night.
All right, moving along. Next application in front of the board this evening is 33 Vinyl Avenue, represented by Attorney Sheehan. This is the application of Vinyl REI LLC, who's in front of the board seeking a courtesy permit for units 1, 2, 3, 4, 5, and 6, all at 33 Vinyl Ave.
Yes, Mark Sheen of Adam Dash and Associates, attorney for Vinyl REI LLC of 33 Vinyl Avenue. My client is seeking courtesy permits for units 1 through 6 of this new construction property. Thank you for your time.
Thank you. All right. At this time, I will make a motion to open the floor for board discussion or questions for the applicant in regards to the courtesy permits for units 1 through 6 at 33 Vinyl. All right, seeing no board discussion or questions, motion to close the floor and motion to open the floor for public commentary. If anyone would like to speak in favor or against the application at 33 Vinyl Ave.
I don't see any hands.
All right. Seeing there is no public commentary, motion to close the floor and a motion for the board to vote on the courtesy permit for the new construction units, unit 1, 2, 3, 4, 5, and 6, all located at 33 Vinyl Ave.
Okay, this is a vote to approve a courtesy permit for units number 1, number 2, number 3, number 4, number 5, and number 6 at 33 Vinyl Ave. Chair Zasloff,
Yes.
Board Member Simeon,
Yes.
Board Member Solis,
Yes.
the motion passes.
All right, thank you very much.
Thank you.
Continuing along, we have the next application from the board is 106 Electric Avenue, represented by Attorney Mascarelli. And that's the application RJM Development LLC, who's seeking a preliminary non-rental conversion permit for units 1, 2, and 3, all located at 106 Electric Ave.
I apologize, Chair Zasloff. We, for whatever reason, I'm having some difficulties with promoting the panelists today, but it looks like we have Attorney Mascarelli.
Hi, can you hear me okay now?
Yes, we can.
Ben also wanted to congratulate you. It's been a pleasure working with you throughout the years. So best of luck with everything.
Thanks very much, Attorney Mascarelli.
So application for 106 Electric Ave, units 1, 2, and 3. Did provide a affidavit that all of the property when purchased has been within the same family for, I believe it's been over 40 years, the McLaughlin family. There was never tenanted. We did provide an affidavit of all of the beneficiaries of the trust, as well as the trustee, and have also provided tax documents showing that the property has always been in the trust. I do have a copy of the current deeds, copy of the master deed, as well as the engineer report from Causa Design Incorporated. So we are pleased asking to have a approval for units 1, 2, and 3 of 106 Electric Avenue.
Okay, thank you very much. Motion to open the floor for board discussion, questions. Seeing no discussion or questions from the board, motion to close the floor. Motion to open the floor for public commentary. If anyone in the virtual audience would like to speak in favor or against the final conversion permit for 106 Electric Avenue, now would be the time to do so.
I don't see any hands.
All right. Seeing there is no one in the public commentary, motion to close public commentary. In reviewing the application, we have all outstanding documents submitted at this time, which include the certificate of good standing, paid water bill, quitclaim deed, master deed, engineer's report, and check in the amount of $1,800 to cover the 3 units. So at this time, I will make a motion for the board to vote on the final conversion permits for units 1, 2, and 3, all located at 106 Electric Avenue.
Okay, this is a motion to vote on a final conversion permit for units number 1, number 2, and number 3 at 106 Electric Avenue. Chair Zasloff?
Yes.
Board Member Simeon?
Yes.
Board Member Solis?
Yes.
The motion passes.
Okay, very good.
Thank you, everyone. Have a great evening.
You too. Thank you. We are on to our final application under the final conversion permit and courtesy permit portion of the agenda. And that is 10 Morton Street. And that is the application of Randall Isaac and Adriana Isaac, who are seeking a final conversion permits for units A and B, both located at 10 Morton Street.
Hi, can you hear me?
Yes, we can.
Sorry, I disappeared there for a second. My name is Randall Isaac, owner with my wife, Adriana, of 10 Morton Street. We purchased the property as a single family property from the owner in March of 2023. We renovated it to a 2-family property, units A and B. We currently live in unit A upstairs and are seeking the final permit for conversion of unit A and unit B.
All right, very good. Motion to open the floor for board discussions or questions for the applicant.
Oh.
Seeing there's no board discussion, motion to close the floor and motion to open the floor for public commentary. If anyone in the virtual audience would like to speak in favor against this application at 10 Morton Street, now is the time to do so.
I see no hands.
Okay, motion to close the public commentary. In reviewing the application, all pertinent documentation has been submitted to city staff at this time. Nothing remains outstanding, so I'm prepared to make a motion for the board to vote on the final conversion permit for units A and B, both located at 10 Morton Street.
Okay, this is a motion to vote on a final conversion permit for unit A and unit B at 10 Morton Street. Chair Zasloff?
Yes.
Board Member Simeon?
Yes.
Board Member Solis?
Yes.
The motion passes.
Thank you very much.
Thank you.
Have a
Thank
great
you very
night.
much.
We are now on to the preliminary condo conversion permit portion of this evening's agenda, with the first application from the board being 57A Cherry Street, and they are represented by Attorney Spang. And that is the application of 57 Cherry Street Real Estate Trust. James Douglas seeking a preliminary rental conversion permit for units 1, 2, and 3, all located at 57A Cherry Street.
Yeah, can you guys hear me?
Yes.
First of all, my name's Matt Spang. I'm representing the 57 Cherry Street Real Estate Trust. James Douglas is the trustee. Before the board tonight, seeking a preliminary rental conversion permit for units 1, 2, and 3. Application is provided, as well as a copy of the $1,800 check to the city of Somerville. Completed application quitclaim deed, paid final water bill, and certificate of good standing. I just wanted to add, I want to thank everybody on the board for tabling this. This was on the agenda for last month. Had some technical difficulties logging in, so I appreciate everybody's patience and tabling this for this evening. So thank you.
All right, very good. Thank you. Motion to open the floor for board discussion. If there's any questions for the applicant.
Chair Zaslav, if I might just add, because I think there was some discussion amongst staff regarding some of the information on the cover sheet that was provided. Our understanding is that there, just for clarity's sake, that while there is a notice period which depends on the status of the tenants as having enhanced protections or not, of 2 years for a vacant unit or 5 years for former tenants, for tenants that have enhanced protections. However, our understanding is that upon the payment of relocation benefits, the waiting period would then end. So just hopefully that is a helpful point of clarification.
And those relocation payments have been made, correct?
Not yet. We're in the process of making all of those and providing the board with the documentation it requires, but they are being organized to be paid.
Okay, all right. Very good. Any questions for the applicant from fellow board members?
Yeah, what I understand is what that means it is on process. Yeah, is that
the daughter for the owner, for the trustee, for Mr. Douglas, she has been emailing the former tenants and coordinating addresses with them, how they want it split up amongst them, and where best to send them the checks.
Mhm.
So for tonight's purposes, board member Simeon, this would be treated as a conditional preliminary
Okay.
application. So it wouldn't come up for final review until those relocation fees are paid in full, and then the master deed engineer report submitted at a future date.
Okay.
They're not paid, and the waiting period would go into would come into play. Am I correct with that statement, Ben?
That sounds right.
Okay. Understand. Thank you.
Okay. Very good. Seeing there's no further questions from the board, motion to close the floor, motion to open the public commentary period. If anyone would like to speak in favor or against the application at 57A Cherry Street, now would be the time to do so.
Okay, it does look like we have someone in attendance that would like to speak. Chica, you're now a panelist. You may unmute and speak.
Great, thank you. Yeah, I appreciate that. Yeah, so I was a former tenant at 57 Cherry Street as of September last year, 2025. I had been there for a year and a half at the time of the end of my lease. I guess I just have a couple questions for the board about this process and specifically tenants' rights in this process. At the time of the end of my lease in September 2025 last year, I actually received, and the other tenants and I received a couple notices from the landlord. First, we received a questionnaire, condo review board questionnaire, specifically for tenants, basically our experience, if we had any issues with condo conversion, if we had been contacted about that specifically, if any compensation had been offered. I think it's a standard questionnaire that's provided for landlords to give to tenants. So we received that first. We also received a notice in the mail, basically saying that the landlord was retiring, and therefore would not be renewing our leases. And at the time, I did reach out to the condo review board directly just to make them aware of the fact that our leases had been essentially ended. and that it appeared that based on the fact that we'd received the questionnaire about condo conversion, that the reason for the lease non-renewal was to convert to condos. Um, and at the time, I guess it wasn't clear. I suppose the landlord wasn't clear about the intent to convert to condos, and so there wasn't much that we could do, I guess, in regards to our rights as tenants to uh, the few items that I guess are normally our rights, namely one, notice period, being able to extend our lease for a year. That wasn't offered or really discussed. Um, there was no offer to buy the unit by the tenants. That wasn't offered at all. And then finally, for the relocation fee, that wasn't brought up either. So at the time, it was really just non-renewal of our leases. All of the prior tenants had moved out. We've been in contact since just about the situation, and I think some of them are also on the call, just in the I guess the waiting room. Yeah, so that's kind of the situation. I think at this point we've all already moved out, obviously, found other places to live. Uh, but it just appears that this wasn't very straightforward in terms of the actual intent to convert to a condo. And it just looks like looking back, um, that was always the intent, was to end our lease so that it could be converted to a condo. And it seems like that doesn't really follow with the tenant's rights document per the condo review board. So I'm wondering why, I guess, why it was approached in that way, and what our options are now.
Um, just Chair Zaslav, I of course will give you the first opportunity to respond, but I want to offer that I'm happy to provide some information.
Sure. Ben, I would defer to you since you've been working with the tenants.
Right. So I'm sorry, is it Chica?
Yeah, that's right. Yep.
Okay, Chica. So my understanding, and something that we have seen in the past is that our ability to deliberate typically requires an application to be before the board. So, in order for the board to have enforcement of what is within the condo conversion ordinance, the application has to be already received by staff. And typically, it needs to be a complete application in order for us to agendize it, to put it on an agenda, where we will again then have the opportunity to discuss and deliberate. Um, in the instance of this application, um, the the hearing that was provided that you described receiving a year ago, we would refer to the questionnaire that you received and the accompanying forms as the notice that had lapsed by the time the application was received by the board. So what we required the applicant to do is to provide updated information, to submit to provide new hearing notices to the tenants, and their notice period is reset. So where in for your typical application where the application was submitted, or a complete application was submitted within 30 days of providing notice to the tenants, the notice period would have begun, excuse me, directly the same date that the notices were provided to tenants. In this case, it started approximately, I guess, 7 or 8 months later. It began when you received the new notices that were sent out earlier this year. So that is just so you can kind of understand the board's approach. And unfortunately, I think there are limitations when it comes to folks such as yourself, former tenants, being able to bring concerns to the board unless there is an active application. Those are kind of the confines of this board, the way that it functions, in my understanding.
Sure. Okay. Um, yep. I guess I just wonder how that would actually allow you to utilize your rights in that case, if there's really no enforcement. If, you can give whatever reason you'd like to get tenants out of a unit, and then afterwards do what you need to do to get around the need to actually extend tenants per the notice period. But I understand what you're saying. I understand it might be just how it is. So okay, one follow-up question maybe, if I could, or maybe we can give the floor to Board Member Solis first. Not sure.
Sure. Board Member Solis, the floor is yours, and then we'll come back to Chica for a follow-up.
Thanks everyone. I don't mean to be dense, but because this is a little bit of a sticky wicket, could you just explain again, Ben? I don't know if my memory is just not serving me well, but so being served the survey is intent to convert.
Yeah, and so yes, so I think that's fairly clear. I mean, that is something that I think the board should take a vote on for this application, but my understanding is that the applicant is willing to make relocation payments. They've expressed the willingness to do so because I think that their understanding is also that intent to convert would have been formed on when they originally sent those notices when the tenants were in units last year. If it's helpful for me to kind of go over this, the timeline of this application, Board Member Solis, I can do that.
Well, I guess so you're saying that the applicant is willing to consider the first survey distribution to tenants as the notice of intent, and that's why they're considering relocation. That's what you're saying? Considering relocation support payments?
I mean, I think I would let the applicant speak directly to that if we want
Okay.
the attorney for the applicant. But that, I mean, my understanding in the discussions we've had with Attorney Spang is that the applicant is planning to make relocation payments.
Okay. So I guess my question is, and obviously, Attorney Spang, I would want to hear that is or isn't the point of view of the applicant. But if it is, I guess my question to Chica is, so what do you feel might not be the right word from your point of view? What rights have you missed out on if the relocation fees are paid to you guys based on that first survey being the notice of intent to convert? Where do you feel like you have missed out as far as your protected rights? Just so the condo board can have a clear understanding of that.
Yeah, no, I appreciate that. Just so to clarify, right? And my understanding of the tenants' rights is that there are multiple and that they are not mutually exclusive, right? So the first one is the right to a proper notice. So when a landlord has an intent to convert to condos and they have current tenants that have leases, those tenants need to be notified and given a year to extend their lease from the point of notice, right? So that was not given. First of all, there was no clear intent from the landlord, no clear communication about an intent to convert to condos. We were given, like I said, we were given that questionnaire, but I actually followed up directly with the landlord and sent an email, and I have that record, and I can share that as needed. But to clarify, that hey, it sounds like you're getting ready to convert our units to condos. We are current tenants with leases, per the condo review board. I sent the tenants' rights document as well. We do have rights, and so I just like to make you aware of them if maybe you weren't, and also discuss, what that means for us because if we're expected to vacate our units, it sounds like based on the condo review board's tenants' rights, we do have protections at least for a year to extend our leases rather than just having them end for whatever reason. And so that first of all, the 1 year notice period wasn't given. The opportunity to extend leases for a year from the moment of notice wasn't given. So I believe we missed out on those, first of all. And then secondarily from there, there's also an opportunity to buy the unit by current tenanted tenants. That wasn't offered, so that was missed as well. And then finally, the relocation fee or relocation payment wasn't communicated about or offered at the time of our tenancy or even after we had moved out until about a month ago, when this discussion, I guess, was started with the condo review board. So, relocation fees are great. I think they definitely have a place and, I think they're helpful, but really, and this is listed in the tenants' rights as well, they're expected to be paid around the time that you're actually relocating, rather than like 9 months after. Otherwise, it doesn't really help you to find a new place, to be able to afford a new place, right? So yeah, and to take all of that in totality, right? I guess what I'm getting at is that it doesn't really seem like the landlord followed the established process per the condo review board for an actively tenanted unit that they plan to convert to condos. I don't have, and I actually said this in the questionnaire. I do have a copy of the questionnaire I filled out. One of the questions on the questionnaire was, do you have an issue with your unit being converted to a condo? I answered no. And at the time, I did not have a problem with the unit being converted to a condo. That's totally the landlord's right. Do whatever you want with the property you own. My concern is that there are tenants' rights and there is a process that's laid out in the condo review board's guidelines that hasn't been followed when that is the intent, when that's what the landlord wants to do, right? So I'm trying to understand why our tenants' rights weren't respected, and at this point, what that means for us. So yeah, hopefully that clarifies.
Okay, and thank you. And so Ben, you're saying that we as a board have no knowledge when a landlord gives his tenants, his or her tenants, a survey that clearly, again, we could vote on it, but I'm going to say, in my opinion, that what, is intent to convert. We don't know, but you're saying to Chica, unfortunately, this is one of our limits is like we have no knowledge that that's been done until an application's actually in front of us. So we aren't able to enforce, we aren't able to protect Chica and his roommates' rights if we don't know they're being. But
Yeah.
if Chica reached out to the condo board right when that happened, I guess even if an application wasn't in front of the board at that point, are we on notice at that point? Yeah.
So my understanding, and Joe may want to speak on this, is that we would not expect the board to deliberate if an application had not been received. So Chica did reach out to us. I can see emails that we received in around June, originally in around June of last year, where he indicated that he had received the questionnaire and filled it out and returned it and indicated knowledge of the ordinance and some rights that Chica believes are afforded to their household under the ordinance as well. So I don't think that it's that specifically. I think part of the conversation here is around current tenants versus former tenants. And again, where the board can't really get involved unless an application has been received, unless they have the opportunity to deliberate. Our staff does typically um, offer to connect to make referrals with our Office of Housing Stability. So with other advocates, and they're including those with some expertise in housing law and tenants' rights that can support you at the time. Um, Again, if you have that option, I hope that you were referred to our Office of Housing Stability at the time that you reached out last year. If you were not, I apologize for that. I think that that's typically our approach when we are hearing from tenants that may be at a risk of losing their housing. And at that point, if are working with an advocate, if you're working with potentially even an attorney that can provide pro bono housing assistance, pro bono legal assistance, or something of that nature, there are some services such as that. Then they can inform you of your rights as a tenant. They can inform you of whether they believe you can remain in your unit, regardless of the fact that you have received perhaps an eviction notice or a notice of lease non-renewal. So that I think that is kind of the role of the tenant advocacy organizations in our community, but unfortunately, it's not the role of the board specifically. But I talked a lot. Joe, I just don't know if you want to add anything to that as well, or if that kind of covered our the bases.
Through the chair, and I think some of these questions may ultimately fall on the applicant as far as kind of process wise why it happened this way, but maybe I can give my summary of the facts in that I think that this is not an application that is following the typical process or the process as prescribed under the ordinance, where what should have happened would be that the notice is provided saying that, intent is formed. There's an immediate application while the property is still tenanted. I think that didn't happen here. So the board is kind of in a position where it's now happening after the fact, where the tenants have already vacated. And it really should have been processed at the time that it was still tenanted, which would have afforded those protections that she had identified, that you would have kind of, it's not exhaustive, you'd have the option to remain in the unit, purchase the unit, or be paid relocation benefits. That didn't happen here. So now we're kind of stuck in a position where we're doing, this is kind of I would say a hybrid of, like, it has in some ways a feeling of a compliance type hearing that we've done in the past where it didn't follow exactly the process. But as I understand, this is not contested as a rental conversion permit. And I think from the board's perspective, why it's being processed this way as a rental conversion permit is, I think, I don't know at this stage what any other recourse for a tenant that has vacated the unit could be under the circumstances, and that these tenants are no longer at the unit, so don't have the ability to remain or purchase the unit because they're no longer there. And I think that's not an unfortunate situation, but I think it's kind of just unfortunately the reality of the facts that we're under right now, and that the relocation payment, I think, is and I don't want to speak too far for the applicant, but I think is kind of in some ways recognizing that this was a rental unit that was going through the process, and hence why the relocation benefits. But I don't want to overspeak. If the applicant has any further clarification, I'll defer to them.
I don't have anything further. I think you guys got it. We're just, doing our best to try to follow, what's in front of us. So,
Okay.
Yeah.
Yeah, no, I appreciate that. Maybe I can just wrap up here. So, or go ahead. I don't know if you had something else.
Attorney Deal, your hands up.
Yeah, sorry. I would just, for everyone's sake, maybe make a bit of a finer point on the board's authority to have the board has in the past conducted compliance hearings when a property is actively tenanted. So I think in this case, I don't think that there was knowledge or a dispute at the time it was still tenanted, but if there are other tenants listening, property owners in Somerville, the board would have the authority, if someone receives a notice and says, I don't believe that I'm being afforded my rights, the board has taken the position in the past that you can come to the board, petition the board and say that you want I think we've structured it as a finding of fact saying that your rights have vested pursuant to the ordinance. And I think that is a measure to kind of make sure that there is the teeth of enforcement. So I just kind of want to make that factual distinction. But I think that as Ben had correctly identified, if the board doesn't know that when it's actively tenanted, that's when you're kind of in a difficult situation.
Okay. Yeah, no, I appreciate that. And just to be clear, I understand, that's how these things go sometimes. Maybe we don't have all the facts. Things can go however. At this point, it is water under the bridge. I think I understand that we might not have the opportunity, as we're not currently there, obviously, to extend a lease that has been ended for 9 months or however long. So that's not my intent to try and claw back, those rights. I think that's past and that's fine. But my intent now is really just to determine the actual date for the conversion, I guess, application. I've heard a couple dates at this point. I think the initial questionnaire was given when we were tenants, back in June or whenever of 2025. And it sounds like there wasn't enough then for that to be an official notice or an official application. So then if that's the case, what is the new date for the application? And the reason I'm asking that is because we're talking about relocation payments, and there was an update to the ordinance as of October of 2025, where there's updated payment amounts. So I want to confirm what those amounts would be. based on that updated ordinance and based on when we're determining the application to actually have been. So I think it's one of two things. Either it was when we were tenants and then those rights should have applied, or it's after we were tenants, which means it should be under the new ordinance for the updated amount. So I appreciate everyone's understanding in this matter. I'm not sure if we can follow up on that separately, if it needs to be offline. Oh, and just to follow up, Ben, I was referred to the Office of Housing Stability, so that did happen. I did go. I think that pro bono work is only available to specific income levels. I wasn't specifically in that range to receive that help, so I understand that. It's okay. Again, at this point, just moving forward, I'd like to confirm what those amounts should be and make sure that at this point we can at least follow the process as it currently stands, and make sure that we're at least compensated for what went down.
Thank you. Board Member Solis.
Yeah, my question is just actually about amount. So if someone wants to confirm the application date, then I might have just a little bit to say.
Yeah, I will try to give a brief overview. I may tag in Joe here as well. We talked about this a little bit. Our understanding is that the date on which the tenants vacate the unit governs the amount of the relocation benefit to which they are entitled. And so my understanding, I think this is what Joe had sort of outlined, what I had explained, is that we wouldn't be able to have a change. The ordinance, the law is effective October 1st, and so we wouldn't have a way to retroactively then apply this new law that was not in place at the time that the tenants vacated to their relocation payment amount. Joe, if I could have explained that better, please feel free.
I think that's an accurate summary, but happy to take any follow-ups if board members have it. I think we're going to go into more detail as needed.
Yeah, I mean, I guess just since the way Chica presented it just would be, so, I'm not trying to make this, super long here, and painful. I'm sure it is already for people, but this one doesn't scream to me like, some of the other ones we've had where, we just don't know. This one's a little bit different. And I know we don't want to punish current applicants for other people's mistakes or whatever. But I guess so is that explanation that you just gave, is that like black and white? Is that an interpretation? Because I sort of I guess if I was Chica and his roommates, I would be coming to you saying the same thing. Like, so you're going to say that I wasn't covered by the ordinance when I moved out because an application wasn't in, but then you're only going to pay me relocation fees that were in the ordinance at that time. So you are giving me the benefit as if the application went in while I was still there, which if it did, I would also get other benefits. It's sort of like making it work for one way for one thing and then making it work for the applicant in the other way. And I guess so for the other rights that weren't able to be afforded because we didn't know about it, and Chica's saying like it's water under the bridge, can't do anything about it now. I mean, my comment would be, well, sure, money solves a lot of problems. So I guess I'm just curious, like, what are the amounts? Because it seems like they're sort of getting, the short end of the stick as not getting some of their rights met, and then even with the relocation fee, which is like one of the three things they are getting, they're being given the lower amount. Doesn't feel great for me. Payments haven't been made yet either.
Yeah,
So I guess, yeah.
if I could just chime in here, I don't feel great about, the whole situation that's come to light on this property. And, as board chair, I don't feel comfortable even conditionally voting on um, this preliminary rental conversion permit until the relocation fees are paid in full. So we do have control over that, and I would like to see those fees paid in full to the former tenants before this comes back in front of the board again for a conditional preliminary rental conversion permit.
Can we confirm what those amounts would be? I appreciate you saying that, and basically what Board Member Solis is saying is exactly the fact that how can it be that at the time there was not enough evidence for it to be an official application and for us to be able to represent ourselves as tenants and take advantage of our rights at the time, but then also after we moved out, and we're no longer tenants and therefore are not afforded those tenants' rights. Also, the landlord can then say that actually they had already submitted their application or their application is somehow retroactive to the time when we were tenants or had immediately just vacated the unit, even though we had vacated the unit under the premise that it was not for condo conversion, right? So I just don't understand how that can be the case on both sides. Either it's one or the other. Either we were tenants and there was no condo conversion and therefore there's no rights, and so they can do what they need to do, and then retroactively when they do need to convert, when they're converting, when they're actually applying, the date of that application should apply to the current ordinance. Or they when they initially gave intent and they initially appeared to be vacating the units, not renewing our leases for the purpose of condo conversion, our rights should have applied then. And if they didn't, is that not a violation of the guidelines? Like, how can it be both ways? I just don't understand that. And I don't know what the point of the guidelines are if it's so easy to circumvent them, to be honest.
Chica, sorry if I could, I mean I would still point to the fact that the application did lapse, right? And so I think there's an acknowledge. I think that we do acknowledge that at the time that the hearing notices were sent out last year, according to the guidance from the ordinance, the complete application was meant to be submitted within 30 days of that having been provided. And that was the reason that we required a new hearing notices to be sent out this year. So just to say that I think everyone's on the same page that the application was not submitted correctly last year. Just to say nothing more than that. There are a couple things. I know that we have someone in attendance that also has raised their hand and would like to speak. But Joe, I think that Board Member Solis and Chair Zasloff may have also kind of asked for clarification about whether we feel about our interpretation of which relocation benefits are relevant to this application. And if you could speak more to that, I would certainly appreciate it. And if this may be a situation where we need to come back and provide guidance for the board as well, in the form of something like a staff report, just suggesting that could be an option. But Joe, I'll let you respond first.
Yeah, just through the chairs.
The floor is yours.
Okay, just want to make sure you have this. So the position in the cover sheet is that the relocation amounts that are relevant, I'm going to give the amount then, but correct me if I'm wrong, it's $12,577.16 for each unit. That is based off of the prior version of the ordinance. So that would be prior to the October 1st amendments. I have to apologize slightly. I think there was some emails back and forth with Attorney Spang over that exact amount. My understanding is that the tenants in both of the units are eligible for the enhanced protections. That's why that number is a little bit different. I think the $7,000 number was cited before, but both units have tenants that are eligible for the enhanced protections. So it'd be roughly 12,000 under the former version of the ordinance. And I think the reason for that would be consistent with, and I will acknowledge that the facts here are not perfect. And I think the application of the ordinance under the facts is not perfect because I think it doesn't follow the contemplated process. But I think consistent with the way that the board has applied and the ordinance sets up when the relocation benefits are paid. They're paid at the time, those that are in effect at the time that the tenants vacate. So I think in this case, it's roughly end of August. And that would have been a period where the ordinance, the new relocation benefits were not in effect. And I would also say that when the triggering, where this is kind of compliance saying, well, when did intent to convert form? It would be in June of 2025. And at that time, I don't know exactly when the ordinance, but you're talking at a period where it's not only like the amendments had not been approved by the city council and may not have even been introduced. So I think the legal distinction I make is really under these facts, if you were to apply the new benefits, it would be giving a retroactive effect to the law, to the change in the ordinance. And I think kind of absent an express provision in that change, generally laws don't have that retroactive effect.
Could we make a motion in this case that they should?
So what I would say is I've given the analysis under the board's past precedent, our past practice, my read of the ordinance. That being said, the board could disagree with that condition, the opinion, but I would say that gives a risk to challenge. But I think that's a risk management question for the board.
If everyone is, we have, since we do have someone else that would like to speak, I'd like to promote them and give them the opportunity here before we continue on. Okay. Steve, I am asking you to unmute. You should be able to speak as well.
Hi, can you hear me?
Yes.
So I just wanted to say, my name is Steve McMorris. I was a resident at 57 Cherry Street until September of last year. I personally would have absolutely taken the opportunity to stay there for another year if we had been properly afforded our rights as tenants. And so by skirting our right for that lease extension, by being like, oh, well, we're retiring, we're not converting to condos, maybe we are, maybe we aren't, they are also able to skirt our additional right to the updated relocation expenses because it would have been assessed at the new rate being a year later. So to me, it feels wrong that two wrongs make a right, where they can deny us one right and then use that as a reason to deny us another right as tenants. So that's all I wanted to say. I understand it's complex with the ordinance and with a lapsed application, but it sounds like this is a new application, but then they can't get around the fact that they made us move so they could convert to condos. So I'm seeking clarity, I guess, on that point.
Thank you. Ben, can you just remind what the payment would be had it fallen under the updated ordinance? Because there's two components to the math. What would the payment have been per unit?
Yeah, we can take a look at it. My recollection is that the application was submitted prior to, I think we would actually need to pull up maybe the cover sheet and also take a look at exactly when the application was submitted. So the amount would either be $18,000 or 80,486. Lauren, I'm not sure if you are able to see this right now as well, if you're able to get it faster than I am. The application, it looks like it came in on January 29th. So my understanding, I believe it would be subject to this amount, to the 18,000. I would need to just, I don't want to give complete confirmation because I know that some updated materials were received.
Yeah, I mean, until the relocation fees at least paid in full, I'm not prepared to put this to vote even on a conditional aspect. What is, um, do we vote to table this until they can prove that the payment's been made in full? I guess that's a question for Attorney Deal.
So I think you have a couple options here. You could, I think really the vote will be to table the application. And it's just, it's a table of the application with kind of an understanding of when you expect it to come back before the board. And then I think it's up to the board to then clarify or decide how much you want to clarify what your expectation of that relocation benefit would be. I think it's another one, like I fully respect the board can make that motion and why you want to make that motion, but it would normally just be, that you grant the preliminary and then kind of those matters get settled. So I think you just might have to give a little bit more direction on kind of the results you want to see, if that's the way you want to table the application.
Yeah, I mean, from my perspective, I mean, there's some unanswered questions here regarding the relocation fees and why they haven't even, been paid in full at this point. So I would like to make a motion to table this application in its entirety until those two sides come to terms on whatever those relocation fees ought to be. And then I'd like to see them paid in full prior to coming in front of the board for the preliminary conversion permit.
Yeah,
So,
and just to clarify, sorry, like the attorney said, they had contacted me just for my updated mailing address to coordinate the payments of the relocation fee. I actually asked them to wait because I knew I was attending this meeting, and obviously their representation is as well. Because based on their conduct so far, I'm not super confident in them following the current ordinance, which is why I'm here and we're discussing this. So my intent in this meeting was basically just to clarify the amount that it should be, which in my opinion is the updated amount for the current ordinance. And so I can respond, I can follow up. I understand it's not necessarily on the board to enforce. I can follow up directly with their representation to let them know what my expectation is and maybe the other tenants can as well. And just to be clear about what our expectations are.
So just to clarify, Chair Zasloff, because it sounded like you were describing wanting to hear kind of the applicant and former tenants come to terms. I think it would be best if we can be relatively clear about what that means, what we're expecting. So whether that would be clearly stating the amount that we of or which the law in effect as of October 1st or prior to that time, the relocation benefit being subject to that, or alternatively, I think some kind of confirmation. I mean, if the board wants to have confirmation from the former tenants that they believe they have been fairly compensated according to one of those two amounts, then that should be clearly stated. But I think either way, just setting forth really clear expectations in terms of when the board is then going to be willing to see.
Yeah, I mean, I think there's a lot of unanswered questions between the former tenants and the city, and I would just feel much better um, putting this to vote if some of that can be ironed out and, clearly accepted and or defined between the city and the tenants on what those amounts are, whether it's truly the 12, 5, 7, 7, 16, or if it's an updated amount. Um, again, it's putting the board in a difficult position where we have to try to make a gray situation black and white in its current state. And I don't think it's fair to the board at this time. Typically, um, these things are ironed out behind the scenes between city staff, the current property owner, his representation, and the tenants prior to getting to the board. And I would.
So, sorry, apologies, Chair Sasloff. I mean, I would say that my understanding and having discussed with Joe, is that I think we provided our guidance based on what we think could be challenged versus what we think is relatively, there's already precedent existing, where there are instances in which former tenants have vacated, and then subsequently receive their relocation benefits based on an intent having been formed prior to their vacating. So I think that was what our response was based on, but
Yeah, and I agree with that. There have been those instances, but there was also not an updated the variable that's in play this evening is the ordinance was updated in October with new amounts. The former sort of precedent is not a black and white situation. It's not apples to apples to the current one in front of the board.
If it helps, just real quick, I can, if the understanding will just be that parties come to terms, I will be very clear and I can communicate with the other tenants for us all to be very clear about what our expectations are for the relocation payments directly with the landlord. And then we can all send emails to clarify that so that our position is clear. If the goal of the board is to have the two parties come to terms, our terms will have been set. They can either acquiesce or not. And at least at that point, it'll be clear, if they're following that expectation or not. And the expectation will be based on the ordinance, of course. So it's not just an arbitrary amount. But we can be clear about that from our tenant side. And then I guess the rest is up to the landlord side.
I mean,
I know this isn't set up as a mediation, you know, so yeah, I'm putting you on the spot here, Attorney Spang, and you certainly don't have to answer, but, I know we're not in a mediation where you have a certain amount you can agree to and like that, but do you have any indication if the client would be willing to consider what Chica's asking?
I don't have any indication. I would have
For
to
the
speak with him. I'd have to speak with him
Yeah.
about that.
Yeah, I assume.
Sorry.
Okay.
so, to the other board members, I mean, we have had in the past tenant owner disputes that have been unsettled that have come before the board, and the precedent that we have followed is to table it and allow the two sides to continue negotiations before it comes back in front of the board. Typically, I mean, from my experience on the board, every time we've allowed that to happen, the two sides come to an agreement, and then the application comes back in front of the board, and it's a much smoother process. I would prefer that to be the case on this particular application tonight. So, I mean, as board chair, I would propose a motion to table the application of 57A Cherry Street, units 1, 2, and 3, on the condition that the two sides continue to work together behind the scenes and come to an amicable agreement within the confines of the ordinance prior to coming back in front of the board.
Okay, this is a motion to table the application for 50A Cherry Street, units number 1, number 2, and number 3, contingent on the applicant and former tenants coming to an agreement regarding relocation benefits and their payment being made prior to the next meeting where we will discuss this application. Chair Zasloff?
Yes.
Board Member Simeon?
Yes.
Board Member Solis?
Yes.
The motion passes.
Thank you.
Thank you.
We will move along this evening. Next application in front of the board is 34 Marshall Street, and that is being represented by Attorney Vigorito. And the applicant is seeking a preliminary rental conversion permits for units 1 and 2, and a preliminary non-rental conversion permit for unit 3, all located at 34 Marshall Street.
Good evening once again, Ann Vigorito, 424 Broadway, Somerville, Massachusetts. I'm here this evening representing the units at 34 Marshall Street, units 1, 2, and 3. The applicants are Mr. Vad and Mr. Kumar. They are respectfully requesting preliminary conversion permits for units 1 and 2 and a preliminary non-rental condominium conversion permit for unit number 3. You do have before you this evening a completed application, notification to the prior tenants, paid fine or water bill with a receipt, a certificate of good standing from the city of Somerville, a quitclaim deed dated September 30th of 2014, the affidavits of Mr. Vad and Mr. Kumar, and proof of residential exemption for the applicants as well, and then a check in the amount of $1,800 for the fees. This property was purchased by the applicants on September 30th of 2014. Since purchasing the property, the applicants have always occupied Unit 3 at 34 Marshall Street. And as stated, you do have the affidavit. Units 1 and 2 at 34 Marshall Street have been rented to various tenants. Unit 1 at 34 Marshall became vacant on or about September 30th of 2025 and remains vacant. Unit 2 became vacant on or about October 31st of 2025 and has remained vacant. Notices to the prior tenants of the applicant's intent to convert are included with our application before you this evening. It is our contention that the purpose of the ordinance has been met since units 1 and 2 are vacant and the prior tenants have been notified by the applicant's intent to convert. With regard to Unit 3 at 34 Marshall Street, it has been owner occupied since the purchase of the property back in 2014. So at this time, the applicant respectfully requests a preliminary condominium permit for units 1 and 2 and non-rental condominium permit for unit 3. You still will need a structural engineer's report and a master deed. And of course, the 2-year waiting period must hold for units 1 and 2. Thank you.
Thank you. All right, motion to open the floor for board discussion. Any questions for the applicant? All right, seeing no discussions or questions, motion to close the floor for board discussion. Motion to open the floor for public commentary. If anyone in the audience would like to speak in favor or against the application for 34 Marshall Street, now is the time to do so.
Okay, please raise your hand if you would like to speak. I don't see any hands.
All right, motion to close the floor for public commentary. In reviewing the application, as the attorney stated, there will be a 2-year waiting period for units 1 and 2. Unit 3, owner occupied. We have the residential exemption for Unit 3, certificate of good standing, final paid water bill, claim deed, and a check in the amount of $1,800 at this time. As the attorney stated, we're still awaiting the master deed and engineer's report. So in reviewing that, I'm prepared to make a motion for the board to vote on a conditional preliminary rental conversion permit for unit 1 and 2, and a conditional preliminary non-rental conversion permit for unit 3 at 34 Marshall Street, conditioned on the waiting period lapsing and the master deed and engineer's report being submitted at a future date to city staff.
Okay, this is a motion to vote on a preliminary rental conversion permit for unit number 1 and unit number 2, and a preliminary non-rental conversion permit for unit number 3 at 34 Marshall Street, conditioned on the master deed and property condition report to be submitted at a future date. Chair Zasloff?
Yes.
Board Member Simeon?
Yes.
Board Member Solis?
Yes.
The motion passes.
All right.
Thank you, Chairman Zasloff and members of the board, and good luck, Ben, and welcome to Lauren. See you soon. Have a good evening.
Thanks, Attorney Vigorito.
Moving along, we have next application is 38 Ossipee Road, and that is the application 38 Ossipee Trust. Rhonda Bartlett Nicoopoulos seeking a preliminary rental conversion permit for units 1 and unit 2 at 38 Ossipee Road.
Hey, I see that it looks like we have the 2 people here that are in attendance on behalf of the application. Is that?
This is Attorney Sheehan. Ben, I have the next one, 24 Ivalou Street. I am not associated with this application on Ossipee Road, though.
Oh, apologies. Thank you, Attorney Sheehan. I think I'm looking at the wrong copy of the agenda over here. Thanks.
No problem.
Rhonda, you are promoted to panelist. You should be able to unmute and
Hi, can you hear me?
yes, we can hear you.
Okay. Good evening to the board. My name is Rhonda Nicoopoulos. I'm owner of 38 Ossipee Road. Thank you for reviewing my application and considering my particular case. We used to live in Unit 1 of 38 Ossipee Road, and since we moved, we have rented both units. Unfortunately, there was an accidental fire on February 3rd of 2025. Thankfully, everyone was okay and everyone was properly relocated. But since that day, the city of Somerville shut the building down. And afterwards, after the emergency mitigation services, the house is basically down to the studs. And it's been a difficult process trying to rebuild. We actually wanted to keep the house as rental housing, but due to the financial burden, we are looking for to convert them to condos. I've notified all the previous tenants, and they are all aware, and they've also given me, many of them have given me letters of support. I just want to say that some of my tenants have been there for well over 10 years. I was always a good landlord, and I know that there is a new ordinance, but due to the financial realities of my family, I'm asking if the board would consider the prior 1-year waiting period instead of 2. The fire was accidental. It was caused by the tenant, and it was not caused by neglect or intent on my part. And we're just we're in the process of rebuilding now, but we've been having trouble with um, the insurance and trying to get the funds. And that's why I'm asking for this unusual condition of asking you to approve and perhaps consider a 1-year waiting period.
Okay, thank you. All right,
Thank you.
motion to open the floor for board discussion, questions for the applicant. Any board members have any follow-up questions?
Hi there. Could you just say a little more about, well, I'll just preface this by saying sometimes we have applications that come in and there's been a fire or a flood or something pretty catastrophic and the tenants haven't been relocated properly, and so they kind of come back because they're notified of the conversion, and we sort of get stuck in a place where it's like we can't really help them as a condo board, but like we're not happy with how things went down, but it sort of opens a bunch of can of worms. And can you just say a little bit about, so you had two sets of tenants in the home at the time of the fire, or three?
Yes, no, we had unit 1 and unit 2 were both rented out. I had 4 tenants. It's a 4-bedroom, unit 2, and unit number 1, 3 tenants for a 3-bedroom. The tenants in unit number 2 have been there. I think 3 of them had been there for 12 years. One of them was new, and that was the room that had the accidental fire. And unit 1 had moved in September 1st of that year of 2025. Unit number 1 called me on February 3rd, I think it was around 2, and said that they had smelled smoked. They had called the fire department. I asked her to see if, anybody else was in the building, knocked to make sure everybody left, that I was on my way. She called me while I was on my way, told me that everybody was out of the building, and the fire department came immediately. And due to the water and smoke damage, the whole place was filled with smoke and the whole place was shut down. The Red Cross showed up. I asked all the tenants where they wanted to go because they couldn't go back into the house. It was just in really bad condition. They all said that they had places where they could go, and then they all found housing right away. And so I had said to them, I followed up with them in the next few weeks with all of them. They signed termination agreements just saying that with their property, some of them had renter's insurance, some of them did not. I worked with the insurance to get them their funds for tenant relocation. And then that's it. And then I notified them in the fall that I could no longer keep the building. I wanted to, but we cannot. So that I was planning to do condos, and if they could let me know if they could give me some support, letters of support, which I think I included several in the package. And that's what happened. Apparently, from the fire report, the tenant plugged her AC directly into a surge protector with other things plugged in that drew like a heavy current, and she had clothes on top of it. It was underneath a cabinet, and I asked why the circuit breaker didn't. And he said it kept looping, that it got so hot, and because there was flammable items on it, it just ignited. So that's what happened that day.
Okay, thanks for sharing. I'm obviously glad nobody was hurt.
Of course. Yeah.
Yeah. Okay. Thank you so much.
Of course.
But
Thank you.
if I understand that since then, no, you don't pay anything, you don't spend money for them or help them on the move or rental or whatever
No,
they have to
they
do,
got
no?
no, they said they were fine. They found new housing right away, and that they got money from the insurance, and that was it. It was an accidental fire. It was caused by the tenant. It was not my fault. I tried to help as much as possible.
Mhm.
Okay, thank you. Any further questions from the board?
I don't know if I see the letters in the drive.
They're in the documentation of notice to former tenants PDF. It has the letters in response to Rhonda's initial communication.
Gotcha. Okay, thank you.
Thank you, Lauren.
I mean, just while we have the floor for board discussion, I'm personally considering making an exception. I mean, forcing this homeowner, it's a private landlord, this is not somebody I would constitute a developer. It's not as if she then sold this property to a developer who's now coming in and not trying to reach the former tenants. Personally, I don't see how holding this owner in this current situation to the 2-year period helps mitigate any sort of housing shortage in the city currently, or you know, continues to help tenants. And that's ultimately, why we're all serving on the board, is to look out for tenants' rights. So I would consider making that exception, but that's up to the other board members to consider also.
Sorry about that. I didn't have the video on. I apologize.
If it is at all helpful, seems like I would just say if it is all helpful there, I can recall an example where they may have been precedent of the board issuing courtesy permits for a slightly different situation. In that situation, I believe there was an owner who did make some financial contribution to the relocation of their tenants. And once again, that was a situation where the applicant was the owner at the time that the fire occurred and had not sold the property. Just harkening back to that, but so it is slightly different. Just sort of providing that information.
I'm curious what thoughts of the other board members. Any thoughts?
Sorry, I was having technical difficulties. Yeah, I sort of am leaning towards what you're saying, Chair Zaslav. I just was reading through the notes, which I hadn't realized were in that folder. So it seems like people feel taken care of, which is what my concerns usually are. So this is not, like you said, we've seen, a flood happen and people not be helped, and then a developer come in, and this is certainly not that situation. So, but yeah, I would be leaning to, oh God, approving the 1 year. Yeah, that's where my head's at.
Okay, board member Simeon?
Yeah, I feel okay with that one.
Thank
You know, as you said, and it's like it is very hard to find, a single, we can say, a family, and they always sell it to the big guy, and then we lose a lot from that. But she deserved that one.
Thank
Thank you.
Okay. Motion to close the floor for board discussion. Motion to open the floor for public commentary. If anyone in the virtual audience would like to speak in favor or against the application at 38 Ossipee, now would be the time to do so.
Give you just a moment to raise your hand if you'd like to speak in favor or against the application. I don't see any hands.
Okay. All right, in reviewing the application this evening, we have their certificate of good standing, paid water bill. We have a quitclaim deed, check in the amount of the $1,200. This time there's no master deed or engineer's report. So I guess I would be looking to Ben for clarity on how to cite this for the 1 year.
I think my suggestion, again, of course, if Joe disagrees, I will defer. But my recommendation would just be to clearly state that the conditions of the permit, and then say with a reduced notice period of 1 year from the date of um, the permit issuance is what I would recommend.
Thank you.
Joe?
Through you, Chair, everything Ben, I'd just maybe add that it's a courtesy permit as conditioned, as Ben stated. I think it would be through the board's courtesy permit authority that you could waive certain requirements.
Remind me never to try to be chair. I wouldn't get the wording of everything correct here.
Hopefully I get it on one try, but
we'll give you as many as you need.
The beauty of a do-over.
Yeah.
Joe,
make Ben work on his last night supporting the board.
Yeah, I know. I'm hopefully right. I hope you're taking notes, Lauren. Joe, just for clarity's sake, though, we're talking about issuing the courtesy permit, in which case there would be no need for a 1 year notice period prior to the final conversion permit. Are we talking about issuing a preliminary permit and then the board plans to issue a courtesy permit following the 1 year notice period having lapsed? I think that would be a departure from typically the type of permit that the board would issue that has a notice period attached to it. Where courtesies are kind of congruent with a final, in that there's no expectation for an additional board hearing.
Through the chair, I think the intent of including the courtesy language would be that, this isn't an application that, or as the motions put forth, that would follow the traditional requirements for those permits. So I think just trying to add some distinction that if it's the board's intent to say it's
as a courtesy, rather than being for a courtesy permit.
I think that distinction is that's a fine distinction.
Okay, let me give it a swing. All right, motion for the board to grant a courtesy exception with the reduced notice period from 2 years to 1 year as of the date of the permit being issued, and conditioned on the master deed and engineer's report being submitted to the city staff at a future date.
Okay, I'm going to do my best to restate that, if it's okay, Chair Zasloff.
Please. Okay,
this is a motion to vote on a preliminary rental conversion permit for unit number 1 and number 2 at 38 Ossipee Road, conditioned on the master deed and property condition report to be submitted at a future date, and with a reduced notice period being provided by the board from 2 years to 1 year as a courtesy.
Perfect.
Chair Zasloff?
Yes.
Board Member Simeon?
Yes.
Board Member Solis?
Yes.
The motion passes.
All right. Thank you. Have a good evening.
Thank you so much.
All
I
right.
really appreciate it.
Thank you.
Okay. Have a good evening. Bye-bye.
Yep. Next application from the board for a preliminary conversion permit is that of 24 Ivalo Street, represented by Attorney Sheehan. This is the application of Mulberry Holdings LLC, Christopher Dawn, seeking a preliminary rental conversion permit for units 1 and unit 2 at 24 Ivalo.
Yes, Mark Sheen of Adam Dash and Associates, attorney for Mulberry Holdings LLC of 24 Ivalu Street. My client is seeking preliminary rental conversion permits for units 1 and 2 of this multifamily residence. My client purchased the property in July of 2024 and has been vacant for over a year. We have submitted the application along with the paid final water bill, certificate of good standing, deed for the property, and a bank check payable to the city of Somerville. And I should clarify, it's been a single family, and it is being a second unit is being created at the property, so it will be a multi-family residence. Thank you for your time.
Thank you. Motion to open the floor for board discussion. Questions for the applicant? All right. Seeing there's no discussion from the board, motion to close the floor and motion to open the floor for public commentary. If anyone in the virtual audience would like to speak in favor or against the application at 24 Ivalu Street.
I don't see any hands.
All right. Motion to close the public commentary. In reviewing the application, there is a 2-year waiting period for units 1 and 2. We have their certificate of good standing. We have a paid final water bill. We have a quitclaim deed. We have the master deed and then a check in the amount of $1,200. At this time, we're still awaiting an engineer architectural report. So I'm prepared to make a motion for the board to vote on the preliminary rental conversion permit for units 1 and unit 2, both located at 24 Ivalu Street, on the condition that an engineer architect's report is submitted to city staff at a future date.
Okay. This is a motion to vote on a preliminary rental conversion permit for unit number 1 and number 2 at 24 Ivalu Street, conditioned on the submission of the outstanding property condition report and master deed to be submitted at a future date. Chair Zasloff?
Yes.
Board Member Simeon?
Yes.
Board Member Solis?
Yes.
The motion passes.
Thank you, everyone. Have a great night.
You too, attorney. Thank you. On to the last application from the board this evening is 85-87 Gilman Street. That is the application of Sonia Song and Insing Chang, seeking a preliminary preliminary non-rental conversion permits for unit 85 at 85-87 Gilman Street. Do we have a representative, Ben?
It looks like we do. For whatever reason, it's there's a bit of a delay in promoting them to panelists. There we go. Okay, Xiaomin, you should be able to unmute now and speak to the board. Xiaomin, are you able to unmute? We cannot hear you currently.
Can you hear me?
Yes.
Uh,
We can hear you.
just a second. Hello. So for some reason, my video is not working. Can you hear me?
I can hear you. Yes. Can you hear
Yeah,
us?
okay. Then I just talk. Mm, so my name is Xiaomin Sang. So I have this two-family home and my present residence since I bought it in October uh, 2012. I've been living there for over 14 years. So right now, I just want to convert my unit to a condo since my family situation has changed. So I think I got all the document like I paid a certified check $600. I have a good standing letter from the city and have a water and sewer bill been paid. And I also have the most recently quarterly tax bill and a copy of the deed.
Okay. Thank you very much. All right. Motion to open the floor for discussion amongst the board. Any questions for the applicant?
Hi there. What about the other unit?
Other unit,
Is
because
it
I
two
have a
units?
tenant there, they're still living there right now. I'm not sure yet. Yeah. If they want to stay, I will let them stay. Yeah.
So you're only looking to convert the owner occupied unit that you live in?
Yes, yes. And this time.
So Chair Zaslav, I don't think I've had this kind of application before, so I just don't know if it's different at all with one unit, not the other. I don't.
I mean, I don't believe so. I mean,
Okay.
ultimately, she can convert the owner occupied unit. Obviously, if she decides to convert the other unit, she'll need to go through the notice period and adhere to all of the rights afforded to the tenants, when converting.
Yeah, I apologize because if I could just take a moment. I hadn't looked at this application prior to the meeting. So Xiaomin, you would need to if you are looking to get your final permit,
Mm-hmm.
you would need to you are meant to submit that application 1 year from the issuance of your preliminary permit.
Uh-huh.
So if you apply for, my understanding is you could apply for this preliminary permits now,
Uh-huh.
um, but there would be maybe an issue in terms of the timing if you planned to convert the other unit as well,
Mm-hmm.
where your permit for this unit, for the non-rental unit, would
Mm-hmm.
would lapse potentially. And
Mm-hmm.
there's so you are meant you need to have registered your master deed 1 year following the final permit, and then you need to have sold the unit 2 years following the final permit. So I think
Oh,
maybe the concern would be if you have not already applied for the other units, then
uh-huh.
it's possible you would just end up coming back to the board for this permit again.
Oh, really? So right now, because I'm not sure the tenant right now, they're this tenant with me in my other property for over 12 years. It's not this one, but they just move in to my other unit, I think about less than 2 years. But their situation looks right now it's not good, and they just when they move in, they said they want to stay as long as and as, as long as possible. And But right now seems their situation also changed. And in like 2 months ago, they said they may end up leaving, July. Uh, so, but I'm not finalized yet, you know. So you think I will be lapsed if I convert?
You might be better off to, pull the application. I mean, I'm not an attorney, and then work with the city to resubmit an application come July when you have better understanding of what your current tenants needs, because the timing's not going to work out. You're going to ultimately cost yourself $600 twice potentially.
Oh, so
Well, I mean,
so what's your suggestion if the current tenant they're leaving July, what's the best I should do? Yeah.
well, I mean, if you know they're leaving in July, and I would go ahead and go through the process and notify them your intent to convert to condos prior to them leaving.
Okay, then if they left, I have to wait another year, or
You're going to need to wait 2 years.
I have to wait 2 years.
So if you submit, sorry, Chair Zasloff, if I could just
Please.
take a moment. So if you submit your application for both units now, while you have tenants, the tenant is still in that unit, there would be a 1 year waiting period.
Okay.
Your tenants would be entitled to certain benefits. So if they then vacate the unit, they would be entitled to a relocation payment.
Okay.
That is either we can look at the amounts. But if they were to leave in July, it would be either $14,378 or $18,486 if they either have someone that is elderly, disabled, or it is a low to moderate income household. If you wait until they vacate the unit, there would be a 2 year notice period. But I would just note that the the board would most likely need to make a determination. They would vote on whether you had intent to convert, and so you still may need to make that payment even if you wait until the tenants vacate. It would be up to the board to decide that.
Sure.
So what I think we usually see applicants do, since there is a longer period, you have to wait a period for the rental units, whereas for the unit that you live in, the non-rental unit, there's not a waiting period. So usually we would see the application happen at the same time, or the application even for the rental unit be the first thing, since that is what you have to wait for. And if the tenant leaves and you make a relocation payment, then the notice period ends. So you don't have to, if you make the payment to the tenant because they vacate, then you don't have to wait the 1 year or 2 years.
Oh,
Does
I
that make
see.
sense?
Okay. So if, for example, if they leave July, if I pay the relocation fee, I don't need to wait. Is that correct?
That's
Okay.
correct.
Oh, okay. And so if right now I just don't want, because they are with me so long, I just don't want put a pressure on them because it seems right now why they leaving because their family issues, I don't want to, put a pressure said, you have to leave by this day or blah blah blah, make their feel, even harder for their life. So if I give them notice now, I have to waiting 1 year. Yeah, is that correct?
If you were to give them notice now, and you make the relocation payment,
Uh-huh.
then you don't have to wait anymore once you make the payment. So if you start the application now,
Uh-huh.
they have until if you let's say in April, you send them notice and you begin the 1 year period. You send them a
Uh-huh.
notice that you are going to convert to condos.
Uh-huh.
Then they will have until they will have 1 year, or
Mm.
it's actually it can be 5 years if they have again elderly, disabled, or low income.
No, they are not.
Okay.
Yeah. Mhm.
Okay. So it
Yeah.
would be in that case, it would be 1 year that they would have to remain in their units.
Oh.
And if they leave the unit and
Mm.
you make that relocation payment, you would need to make that payment. Um, then the notice period would end, and you could get your final permit. But just to
Mhm.
be clear, the relocation payment isn't something that's optional. It's not something
Mm.
that you can just do to end the notice period. It's something
Mhm.
that you would need to make. You would be
Okay.
required to.
Okay. So the best way probably for me is if they said July will definitely move out because then I just pay them the relocation fee and no waiting period. Yeah.
Um, yeah, so that's right. The notice period would end if they move out and you make the
Pay.
payment.
Okay. Okay.
Joe, did you want to add something?
And I just wondering right now I paid $600. Is this can be I need next time if I apply, I have to pay another $600 for this unit or I just wondering, yeah.
So normally the fee cannot be refunded,
Mm-hmm.
but I had this is something I guess we should talk about with our staff. But I have seen applications where they will pay for some units
Mm-hmm.
initially, then we will realize that they need to make an additional payment
Mm.
at some point, and you would not have to pay twice for the same unit. That's my
Okay.
understanding. I don't think that we would normally do that.
Uh-huh.
But Joe, did you want to speak on that or?
If the chair will recognize it, just if I may maybe step outside in my zone and maybe make a recommendation that I think that it sounds that staff might need to have some additional conversations with this applicant so we can fully flesh out the facts. And it may make sense if the applicant is also willing to potentially table this application as well. That way that they're still in active application, but staff can have more of a one-on-one meeting and discuss kind of what's happening at this property and all the intricacies of the ordinance.
Mhm.
I think that's the
Thank
best of action is for the board to vote to table this evening and have city staff work with the applicant to better understand the ordinance and the avenues in which that they can maneuver within.
Great. And just one other note that it looks like the check may not have been deposited yet. So
Mm-hmm.
we may we can reach out to our finance team and
Mm-hmm.
ask them if they can still if it has not been deposited, if we can just get it back to you, we can return it to you.
Okay.
So we will look into that tomorrow.
Okay. So yeah, if tenant move out July, I can do mm, I pay the relocation fee. I can do the, how to say reapply. Yeah. Uh-huh.
Yeah.
Okay. Okay. Got you. That's very good for me. Yeah, because I don't know this information. Sorry. Yeah. Mhm.
Yeah, no problem. It's
Yeah. Sorry. Yeah.
complicated, and that's what the city staff's there to
Yeah.
help applicants navigate the ordinance and all the requirements. So at this time, I think it's in the best interest for the board to make a motion to vote to table the application of 85-87 Gilman Street until the applicant can work with city staff to have more clarity around the process and timing of the conversion.
Okay. This
So
is
Sorry for one
can I
second.
have one more question? Sorry, if I convert this 2 unit to the condo, I have to sell both?
you may keep the you are required to sell the rental unit, is my understanding. You in order for your final permit to not lapse or to be valid, you would need to sell the rental unit. That is not a requirement for the owner occupied unit.
Okay. For example, so because if the tenant move out 87, can I in the future move uh to the 87 and sell the 85 currently I'm living? Can I keep 1 unit for myself?
It may be something that we should also discuss
Yeah.
among staff, since we already are planning on doing so.
Okay.
Yeah, my question was going to be, Ben, should Shauman reach out to Lauren, or will someone reach out to her? What would be the next step for her to get, because then you can go over all the different options together.
Okay.
Yeah.
Okay.
What should she do, or what will
Yes. I'm hoping that Lauren can follow up. Great. So Lauren will follow up with you, Xiaomin, and
Okay.
I'm happy to also be a part of the conversation. I think it would be good to just schedule a call, a time that we can all get on a Zoom call, and talk through and answer any questions you have.
Okay. Great. Thank you so much. Yeah.
Okay.
Okay.
Yeah. Thank you. Yeah.
So at this time, motion for the board to table the application 85-87 Gilman Street until city staff and the applicant can review their options.
Okay. This is a motion to table the application for a preliminary non-rental conversion permit for Unit 85 at 85-87 Gilman Street. Chair Zasloff,
Yes.
Board Member Simeon,
Yes.
Board Member Solis.
Yes.
The motion passes.
Okay. Thank you. Have a good night. All right. On that note, motion to adjourn this evening's meeting.
I second it.
All right. Ben, best of luck. Thanks again
And
for all
thanks so much.
your help, and thank you for rewording all my my motions to fit within inside the box. So thank you.
No, thank you everyone for your patience and understanding with me as well. I know it's not an easy task for board members or staff to really understand everything until you've been through it and seen it, and just yeah. So thank you, and stay in touch, please. And if you're ever curious about what I'm doing and inclusionary housing, then definitely please reach out, because that is the work that I'm doing now on a regular basis.
All right. Best of luck.
Awesome.
All right. Thanks so much. Take
Yeah.
care.
Take care. Bye.
Bye, everybody.
Good luck. Okay, bye guys.
Bye.